evidence collection purposes. Once the warrant is served and the blood sample is provided to law enforcement, again, that goes to TBI for blood chemistry testing for purposes of impaired driving. We're not interested in affecting or interfering with any other treatment protocols that healthcare providers do for treatment purposes. They just maintain the sample that we can obtain by the warrant.
All right. So the warrant is not after any test results. It's just after the blood.
After it's drawn, yes, sir, and as soon as practicable.
Okay. And if let's say if an eager law enforcement officer or prosecutor or whomever wanted to pursue that path, would this allow them to do it?
No, sir. In that case, if we were attempting to get some other evidence of post-draw testing from the hospital, we'd have to subpoena or do a search warrant for medical records at that point.
Okay. Right. Thank you, sir. Thank you, Chairman.
Yes, sir. Thank you. All right. Our list is exhausted. We're going back into session. Thank you for being with us today.
Thank you, Mr. Chairman.
Any questions for the sponsor? Questions been called? Any objections? Seeing none, we're voting now to send House Bill 2386 as amended to full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move forward.
Chairman, thank you. Committee, thank you.
Yes, sir. Thank you. Let's go to item number 11. House Bill 2865 by Representative Baum. All right, you are recognized. You do have an amendment code 15749. Do you wish to proceed with that amendment?
Please.
All right, you recognized on the amendment.
Thank you, Mr. Chair. This is a bill that provides clarifying language to existing code. What it does is it attempts to make clear that a court that has criminal jurisdiction is eligible for grant funding from the Tennessee Department of Mental Health and Substance Abuse Services for a veterans treatment court program. In this language, it makes it clear that the county would provide the court space and the judge and any equipment and supplies that are needed. And what the grant funding would provide would be program items for the veterans, like substance abuse treatment, mental health treatment, drug testing, and things like that. The grant funding would not go to fund the courtroom itself or the judge.
Any questions for the sponsor on the amendment? Seeing none, we're voting to attach amendment code 15749 on the House Bill 2865. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt. We're on House Bill 2865 as amended. Any questions for the sponsor? Seeing none, we're now voting to send House Bill 2865 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you all.
All right, go with me to item number 28. Item number 28, House Bill 2753 by Representative Carr. You do have an amendment code 17303.
That is correct.
All right, you're recognized on the amendment.
Thank you, Mr. Chairman. This bill here is about nothing but a report that we're asking the DAs to bring to us. And would you like me to explain the amendment first?
I tell you what, if you want us to adopt the amendment, we can do that, and then we can talk about the bill because it rewrites the bill, correct?
Not entirely, but
okay,
yes,
well,
but go ahead. Yeah.
All right. We'll, all those in favor of adopting amendment code 17303, say aye. Aye. All right. All those opposed? Ayes prevail. You adopt. We're on House Bill 2753 as amended. Go ahead and tell us about it.
You are correct, sir, that we adopted that amendment, and it done a couple extra things that the DA's conference wanted. They wanted, first of all, to we're going to set this program out for 2 years to give them time to get their new equipment in place to take care of this. And also, it only reports back to the governor and to the Speaker of the House, Speaker of the Senate, and to the respective committees that it needs to speak to. What we have here today, Mr. Chairman, is folks in my district across Tennessee, we're worried about crime. and they have the right to be worried. Tennessee is now the third in the nation of violent crime. And you can turn on your evening news at any time across to see how hard it is, and we see why that this is happening. Crime is a complex thing, and we should all agree that prosecutors who enforce the laws fairly, thoroughly, and reasonably are a critical bulwark or a defensive wall in keeping every community safe. That's just what this House Bill 2753 does. We've seen the efforts of so-called progressive prosecutors across America. They've used the platitudes of the politicians, but they do not use the authority of their offices. They talk about eliminating mass incarnation and ending systematic racism and all that, but we have the debate. We can have that debate later on this, but what we're here to do now is to level the power of the prosecutor or not prosecute criminals. So what do they do? They choose not to prosecute criminals. They choose to prosecute criminals for minor offenses when they commit major offenses, and they declare publicly or quietly as a matter of policy that they will not prosecute whole categories. Now, with that happening, we have a written criminal code, and we and the public ought to know whether a prosecutor is enforcing the law, sidestepping the law, or subverting the law. That's what this report does. It does not require the district attorney general to change what they're doing. It just requires them to tell us once a year what they've done. In other words, tell us how many folks were arrested for what crimes in your district and what you did with those arrests. How many of the cases were dismissed? How many of the cases went to plea bargain? Or how many went to trial? Every case is a little different, and prosecutors do and should do a lot of discretion. This bill does not change that. We won't be asking for information in individual cases or second-guessing individual decisions. This bill will simply give us the opportunity to look at big, aggregate trends. Just for example, if you were in some city and they had 25 arrests made in Chattanooga, Knoxville, Sevier County, wherever, for a drug possession, and then these 25 arrests were all dismissed, then that would lead the law enforcement to maybe not even try to do those arrests. And that's all we're trying to do is we ought to know about what we don't know. We just want to know what they're doing with all the prosecuted cases in there. And I'll stand with any questions, Mr. Chairman, but we do have a witness here if you would like to go out and hear the witness at this time.
All right, we will go out of session to hear from Mr. Alan Ostergren.
Ostergen,
Ostergren?
Uh-huh.
I told you I'd mess that up. You
You can stand up here.
can stand right there if you like to. If you will, introduce yourself for the record. You'll have 3 minutes for comments, and then the committee can ask questions.
Thank you, Chairman. My name is Alan Ostergren. I'm an attorney from Des Moines, Iowa. I was a prosecutor for 23 years. I started as a rank and file prosecutor in the trenches, and then I was the elected for 3 terms. We call the position county attorney in Iowa, but you would call it district attorney in this great state. I'm here today on behalf of Opportunity Solution Project, which is working on this bill to increase transparency, to give the people of Tennessee information about what's going on with their local district attorney's office. It's very easy when you're in the trenches in the criminal justice system. You know that you're very busy. You know that there's a lot of serious cases on your desk. But from that position, or even if you're the elected, you can't always get a good sense of exactly what's going on in your jurisdiction. And what this bill does is it leverages the power of the case management software that district attorneys are bringing online in their offices to gather data in one platform, in one comprehensive way, where you can make apples to apples comparisons in an office from year to year, but between offices as well, so that policymakers like yourselves and also at the local level can look at trends of prosecution. And it's not just, well, I heard that there's a lot of probation being given at the courthouse, that you can actually get real numbers. How long does it take a case to go from an arrest by a police officer all the way up to disposition in court? That data will be very valuable at the local level and at the state level to understand the job that prosecutors are doing. And I can tell you, as somebody who has been in that role, I would have craved having this level of data in my office to know what we're doing. I started long enough ago. I had the first cell phone issued to a prosecutor in my office, and we still had all of our evidence on VHS tapes. And so some of the young staffers can get that explained to them what that means later. But we're in an era now where I think where people expect that kind of data from their government, expect that accessibility of data from their government, and it will assist Tennesseans in knowing the important work that prosecutors are doing. I thank you for the time to be able to speak to you today. I'd be happy to answer any questions that you might have about this bill.
Thank you for your comments. Members, we have any questions for our guest? Seeing none, thank you for being with us today.
Thank you, Chairman.
We're going to go back into session. We are Representative Johnson.
Thank you, Mr. Chairman. I want to make sure I didn't miss this. But it says non-personally identifying information. So we're not talking age or anything, or are we just talking what the crime is and the numbers?
You're exactly right. We're just talking what the crime is and what the number is. Let's say, for example, in the far west, that they have had 250 cases of human trafficking. Well, or maybe we've had the same thing up in Bristol or whatever. That lets us know that it's happening on the border states or whatever. That we're just wanting to know what cross country and across what each DA is doing, what they're prosecuting, how many they're prosecuting. That way we can set trends, or we can set trends and know what, as a legislature, what and where we really need to focus some of our laws on, or what we need to do with what's been done.
Thank you.
Any other questions for the sponsor? Seeing none, we're voting now to send House Bill 2753 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you, Chairman and Committee.
All right, item number 4. I'm sorry, item number 5. House Bill 687 by Representative Freeman. You are recognized.
Thank you, Chairman and Committee.
You do have an amendment code 14539. You wish to proceed with that
I
amendment?
do, yes.
You are recognized on the amendment.
Thank you, Chairman and Committee. What this bill does is allows for people who have completed their sentence, have their voting rights restored if they are otherwise eligible. Currently, the process is fairly cumbersome and confusing. And we have several people who are eligible to vote that are unsure how to get those voting rights back. This would make it an immediate process. And with that, I stand ready to answer your questions.
Any questions for the sponsor on the amendment? Chairman Halsey.
Just want to make sure I understand, once the sentence is served and they're out, they're eligible to vote by law, even though restitution haven't been paid or fines or fees or any of that. Am I reading that right?
And 9 noes.
Amendment code 14539 fails. We are on House Bill 687.
I'd like to withdraw the thanks.
Okay. Without objection, sponsor moves, take it off notice. House Bill 687 off notice. Let's go to item number 37.
I'd like to take this off notice as well.
Okay, without objection, House Bill 85 off notice. Item 38, House Bill 1878 by Representative Freeman.
And I have an amendment, drafting code 17068.
Okay, you recognized on the bill, the amendment code.
We'd like to go ahead and put the amendment on and then discuss the bill. It makes the bill.
Amendment code is 17068. You're recognized on the amendment.
Thank you. So in Tennessee, we have the Victims Compensation Fund, and for rape kits, we only give $1,000 to pay for something that costs as much as $2,500. We are requiring nonprofits to raise money to pay for the balance of these kits. I can't think of another criminal process where we are requiring the victims to pay for their testing. And with that, I ask for support of the bill, the amendment.
Leader Lamberth.
Thank you, Mr. Chairman. And when I saw the original bill, I wasn't really sure where you were headed with this, but with the amendment, definitely fully support this. Appreciate you bringing the bill. I know that your family has worked in this area for a while, and it's something that's very important, I think, to us all. So I appreciate you bringing the amendment. I do know that it comes with a fiscal note, but I hope it's one of those type things. I still think we're early enough in the process that, I mean, it's not an insurmountable fiscal note and it's money well spent, just my humble opinion. Thank you.
Leader, thank you for that.
Any other questions? I do have a question on the amendment. So these instances where victims are having to pay for their test kits, can you expand upon that?
Sure. Yeah, sure. So someone is the victim of rape. They go to a medical facility and or a nonprofit testing facility. They have a rape kit taken. The victim's compensation repays the $1,000. The group is responsible for coming up with the balance of that money. If it's a hospital, they traditionally will have a charity fund that sits within the hospital. If it's a nonprofit, they go out and call Tennesseans, people like us, to raise money to pay the balance of those funds.
Thank you.
Yeah, thank you.
Representative Towns.
Mr. Chairman, this makes no sense at all, where a victim is left strapped to having to come up with their defense funding. Okay, and I would hope that whatever the fiscal note is, especially as it relates to rape or murder or any of these things, that we would get this passed. Now, if this occurs and there's no funding, does that impede the progress of being able to prosecute the case?
I mean, yeah, it could if they don't have a test because they don't have the money to pay for it. If I'm being totally honest, I'm unaware of any instance where that happens.
But it could. The possibilities there without the funding.
Yes, sir. You're correct. It could.
Which makes it very dangerous. Okay, I'd love to sign on to the bill as well. Thank you for the bill.
Thank you.
Chairman Halsey.
Thank you, Mr. Chairman. Help me understand, every time I ever dealt with this in the police department, somebody called in, police get involved in it. It's the department that orders the rape kit and takes the evidence into custody and sends it to the TBI crime lab. How would you have an event where that did not occur? Would it be on a case where they didn't report it to law enforcement, but they went on their own to the hospital?
No, sir, I'm confused what you're asking. Well, the rape kit is the possession of the law enforcement. The hospital or the same nurse is the one that actually provides the medical procedure, which is the process of taking the DNA samples that makes up the kit. And that's what this addresses directly. And currently, a victim's compensation repays $1,000 for something that the process costs $2,500 or $2,500. So while I think I understand what you're asking, it's not relevant to what this is, because it's the police officer is not the one that's actually taking the samples for the rape kit.
That's true. It's just this department is who ordered it, so the department is who gets the bill, is what I was saying. I didn't realize there were places where that did not happen.
Any other questions on the amendment? Seeing none, we're voting to adopt Amendment Code 17068 on the House Bill 1878. All those in favor say aye. Those opposed? The ayes prevail. You adopt. We're on House Bill 1878 as amended. Any questions for the sponsor? Seeing none, we're voting to send House Bill 1878 as amended to full criminal. All those in favor say aye. Those opposed? The ayes prevail. You move forward.
Thank you, Chairman and Committee.
Yes, sir. Thank you. Item number 41, House Bill 2223 by Representative Love. When you get there, you're recognized. You do have an amendment code 15559.
Yes, sir, Mr. Chairman. Chairman.
All right, you're recognized on the amendment.
Thanks, sir. Members and Mr. Chairman, we have a bill here that extends the age of persons who can be identified as missing from 21 to 25. We found that oftentimes persons go missing and they fall outside of the range of the Amber Alert. We didn't want to increase the number of Amber Alerts going out there to put a stress on TBI. Let me thank TBI for working with me on this piece of legislation. And so what it will do, it'll allow law enforcement to then alert media and send other ways out if persons 25 and younger are missing.
Any questions on the amendment? Seeing none, we're voting to adopt Amendment Code 15559 on the House Bill 2223. All those in favor say aye. Aye. Those opposed? Ayes prevail, you adopt. We're now on House Bill 2223 as amended. Representative Towns.
Mr. Chairman, thank you. As well, Representative Love, would this help in the situation where the young man unfortunately here in Nashville met an untimely demise had we not been able to find him?
Yes, sir, it may have.
How old was that young man?
If he falls between that age of 25 and below, it would have helped out.
I was curious, was he under that, was he in that range? I think he might have been in his 20s. I think he
Yes, sir.
Okay, 22. Okay, thank you for the bill.
Any other questions for the sponsor? Seeing none, we're voting to send House Bill 2223 as amended on the full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you, Mr. Chairman and committee members.
Item number 8, House Bill 2898 by Representative Kumar. You are recognized. There is 2 amendments with this bill. Do you?
Thank you,
have
Mr.
one
Chairman.
that
We're
you're looking to go
attaching
with?
17203.
Amendment Code 17203 is the amendment you wish to go with.
Yes.
All right, you're recognized on the amendment.
Thank you. The amendment makes the bill.
You want to adopt the amendment and then talk about the bill?
That will be good.
Questions called. Any objections? Seeing none, we're voting to adopt Amendment Code 17203 on the House Bill 2898. All those in favor say aye. Aye. Those opposed? Ayes prevail. You adopt or own the bill as amended. You're recognized.
Thank you, Mr. Chairman. And members, this bill is to be called Savannah's Law. About 2 years ago, there was a tragedy in our small community in which a young lady who worked for law enforcement, actually worked at the sheriff's office, was shot in her home and the house was set on fire. It happened because despite working in law enforcement, being aware of the criminal scene, this young lady was a trusting person and she was dating a person who had a past history of violence. She was not aware of it. And 4 to 5 days prior to this incident, she did realize that this was inappropriate and she did inform law enforcement. But just 4 days later, this person came to her house, parked his truck in the driveway, stayed there a while, and she became concerned. She did call the sheriff's office. Of course, she worked there and the people there knew her and she was a much loved coworker. However, before law enforcement was able to get there, the horrible tragedy occurred.